Warning! Other people can find out what sites you visit on your computer. This is true even if you delete your browsing history. If you are afraid someone may be watching what sites you visit, do not watch this video from a computer or phone that anyone else can use. For more information or help, call the National Domestic Violence Hotline, 800-799-7233 or TTY 800-787-3224. Domestic Violence Restraining Orders. How to get a restraining order. For petitioners. This video shows you how to get a domestic violence restraining order to protect yourself from harassment, emotional or mental abuse, stalking, physical or sexual violence, or threats of physical or sexual violence. Remember, you are not alone. Your local court has a self-help center that can give you information and help you fill out the forms you will need. The court's website also has information and resources that can help you. You can ask the court for a domestic violence restraining order if you feel unsafe because your current or former husband, wife, boyfriend, girlfriend, or close relative, like a grandparent, parent, brother, sister, grandchild, or in-law, has committed or threatened violence against you or your children. The order would restrain or limit the abuser's behavior. If your relationship with the abuser does not qualify for a domestic violence restraining order as just defined, there are other kinds of restraining orders you may qualify for, like a civil harassment restraining order or an elder abuse restraining order. The California Court's self-help website has information about the many kinds of orders that may fit your situation, and your local court's self-help center can help you decide which kind or combination of restraining orders will help you. Restraining orders can do different things to limit the abuser's behavior, such as requiring him or her to not harass you, stay away from you, and not contact you. You can find out about other kinds of orders at the California Court's self-help website. But what if you need protection right away? There are a few ways to ask the court to protect you right away. If the police are called to a domestic violence scene, an officer can ask a judge, day or night, for an emergency protective order. The emergency protective order orders the abuser to not contact or harm you and stay away from you and your children or other members of your household. An emergency protective order is a temporary order. It usually lasts just 5 to 7 days. It's designed to be a way for you to get the protection you need to be safe quickly. If you need protection for more time, you must ask the court for restraining order forms. As the person asking for protection, you would be called the petitioner. That's because you are petitioning or asking the court to take action. The person you want to be protected from is called the respondent. That person is responding or answering the order. If you decide you want a domestic violence restraining order that lasts longer than the emergency protective order, you need to fill out some court forms. The forms ask questions about who you are, who you want protection from, what exactly the respondent did that was abusive, and what orders you want the court to make to protect you. You have the right to keep your address and any children's address information private to protect yourself. You do not have to write where you or your children live, work, or go to school, but you must still list a safe mailing address on your form so the court can communicate with you. You can ask the Safe at Home program for a safe mailing address. Safe at Home is a Secretary of State program that gives safe addresses that will be accepted by any California state, county, and city government agency. The Safe at Home program gives victims of domestic violence, stalking, sexual assault, and human trafficking a way to keep their address hidden from the respondent. This helps to keep you safe. This service is free to California residents who qualify. You can reach their services through their website at www.sos.ca.gov/registries-safe-home, or by calling toll-free at 877-322-5227. When you've filled out your forms, take them to your local self-help center for review or take them directly to the court clerk. The clerk will stamp your forms and give you copies. You do not have to pay anything. The next step is to arrange for the respondent to be served. That means someone who is at least 18, not you or anyone else involved in the case, must personally give the respondent copies of the forms you filed at the clerk's office for this case. The sheriff's office can serve the papers to the respondent for free. After serving the respondent, the person who served the papers must fill out and sign a form called Proof of Service. The server will give you that form, then you must file it at the court clerk's office. Service is very important. There are strict rules and a firm deadline. The respondent must be served at least 5 days before the hearing date. Proof of service is important too. If you don't file it, the court may not know that the respondent was served and your restraining order may be delayed. The court will decide to grant or approve your temporary restraining order for immediate protection by the next business day. After that decision, it takes about 3 weeks to have a court hearing about the permanent domestic violence restraining order. At the court hearing for a permanent domestic violence restraining order, the judge will decide to issue a restraining order that could last for up to 5 years. Because the courts are very busy, the hearing will be very fast, usually around 20 minutes. Both you and the respondent will have the chance to explain your side. But the judge will get most of the information about your case from your forms. That's why it's very important to put the information you want the judge to know on your forms. When you're in the courtroom, please sit quietly until your case is called. The court staff will tell you where to sit and when it is your turn to talk or to ask questions. You should also listen to other instructions from the bailiff or court staff. You can bring an adult support person with you to court, but that person is not allowed to speak for you. Unless your courthouse has child care services available, you must make arrangements for someone to care for your children. At the hearing, the judge will ask the respondent what he or she wants to say. The judge usually asks if you have other things you want to say that you did not put on your forms. After hearing from both sides and any other witnesses, the judge will decide your case. If the judge agrees that you need protection, the judge will grant or approve the restraining order. To do this, the judge signs a form called Restraining Order After Hearing. Then a court clerk files it and gives you enough copies for you and for the respondent. If the respondent doesn't go to the hearing, you must make sure the respondent is served a copy of the Restraining Order After Hearing form. You must also make sure a proof of service is filed with the court to prove the respondent received it. The sheriff's office can serve the papers to the respondent for free. Once you have a restraining order, you should always keep a copy with you. You should keep one with you, another in your car, and one at work. Once the restraining order has been filed and served to the respondent, law enforcement can enforce or make the respondent obey the restraining order. The respondent can be arrested, put in jail, and made to pay a fine if he or she does not obey the terms of the restraining order. You may want to know how to change your restraining order or how to make it last longer. We'll cover that in the next video in this series. You can find all the forms we talked about in this video, as well as more information at your local court's self-help center or family law clinic, or online at the California Courts Self-Help website at www.courts.ca.gov/self-help-domestic violence.